for the time being, we are concentrating, Andrew and I, on Brexit. And Andrew, I think you're starting, aren't you?
I am indeed. Well, it's very appropriate to be starting at the time we're at. If we could advance the slides forward. The reason I say that is that, to misquote Nehru, at the stroke of the midnight hour, that's to say Central European time, not UK time, is going to be 11 p.m. UK time. On the 31st of December, the transition period is going to come to an end. And as I'm sure everybody is aware, the significance of that is that whether or not we have a deal, it's not going to include continuation of the current EU civil law regime relating to jurisdiction and enforcement and recognition of judgments. And the purpose of our webinar this morning is just to go through really what the significance of that is. What does it mean? What does it mean for our cases? And perhaps more importantly, what can we do about it? Or more properly, what do we have to do about it right now? Because what Sarah and I are going to be really making the point, I think, again and again in the course of this is there is very little time left, but there is enough time, and you do need, we think, to get on issuing and serving to, really give away the big secret that we're going to be moving towards in the course of this webinar. So it's useful to look at how the current rules work for us at the moment to be able to see where the really important differences are going to be after 11 p.m. on the 31st of December. So starting with jurisdiction, I think that really is the most immediate issue. Obviously, this is governed at the moment by Brussels recast, and the big advantage that this has, apart from the fact that we're all familiar with it and understand how it works, and the courts too, is it's very, very clear, it's very, very certain, and it has very, very little room for wiggle room, which means you get, in most cases, a very clear answer about whether or not the court has jurisdiction in a particular case. And as we've said in the PowerPoint here, you can't defeat the correct answer to jurisdiction by reference to forum non conveniens and the case of Aruso, which is on there. And if we can go forward a slide, the Brussels regime provides that in general terms, defendants must be sued in the courts of their domicile. But this is subject to a number of extremely important exceptions. And they're so important that really for certainly most of the cases that I do, we're looking at the exceptions rather than the general rules. So particularly tortious and contractual claims are governed by Article 7 of Brussels. Article 8 provides for multiple defendants, which means that, for example, in some cases where you have an injured claimant who has claimed on their insurance, applicable law might require the insurer to be joined. The insurer can do that under Article 8. Section 3, really important, because that's what gives the courts here jurisdiction in claims, Odenweit claims brought against overseas insurers. And of course, it is this regime in Brussels recast that enables us to serve proceedings on UK handling agents of insurers as per the case of Spedition. So this really is the regime that enables us to bring so many cases where the defendant is overseas here in these courts. And it's not just insurers, it's also a specific section on consumers, which enables claims in relation to consumer contracts where the consumer is here to sue here. And that enables the courts in this country to look at some cosmetic surgery claims if you've entered into a contract with an overseas provider, or accommodation claims similarly when you've entered into a contract with an overseas accommodation provider. And all of these enable these claims to be brought here. Well, that is most of what I was going to say about jurisdiction, because these sections here, we've got employment contracts, not really in the scope of this talk, jurisdiction clauses, generally enforceable under the recast Brussels regime. Important rules in section 9, which basically torpedo the Italian torpedo, which is to say they mean that there are very clear rules about avoiding irreconcilable judgments and multiple proceedings in different jurisdictions, and also to prevent the Italian torpedo, which is a mechanism enabling somebody to sue in a particular jurisdiction and essentially clog the claim up for potentially years while that court decides whether or not it has jurisdiction. I've just been asked whether we can torpedo a torpedo. How is that? I think it's perfectly possible. If you fire a torpedo at a torpedo and destroy the torpedo, how many, this is like some sort of joke about how many times can two lawyers say torpedo in a sentence? Far more than I would want to count. I'm feeling like I'm being slightly torpedoed off-piste myself to mix my metaphors. But essentially, it's impossible really to emphasize how important recast Brussels is in this area for all of these reasons. And as I say, it's what gives the court jurisdiction in most of the cases that we deal with in this area. We can move on a slide, please. The other really important thing about the Brussels recast is recognition and enforcement of English judgments abroad. And really, Brussels recast is as close as you can get to providing a passport for UK or English judgments so that they just work in other member states. And that applies for enforcement and also for recognition. So you can see here, I've included the section in the slides. Articles 36(1), a judgment essentially in England and Wales shall be recognised in other member states without any special procedure being required. So it is just recognised as it is as a judgment of the courts in England and Wales. And then Article 39, enforceability. The judgment, again, is enforceable in other member states without any declaration of enforceability being required. So, I mean, it's no good having jurisdiction if you get a judgment that isn't recognised in the place where the defendant is domiciled, or indeed one that you can't enforce in the place where the defendant is domiciled. And Brussels recast gets you round all of those issues in a very, very straightforward way. And I also think that may have an implication for some territorial exclusion clauses in insurance policies, because I've seen ones where the exclusion isn't simply about the territory, but refers to judgments which are recognised by particular courts. And to my mind, the Brussels recast means that an English judgment wouldn't fall foul of those provisions because it is recognised automatically recognised automatically by reason of these provisions. I can see we've just had a question about the Lugano Convention, and I'm very happy to say that that is something which we're going to come on to later. So this is the importance of recast Brussels for recognition and enforcement. We can go forward on a slide. Yeah, so what does this mean? Well, hopefully I've answered that already. Basically, the short answer is jurisdiction, recognition and enforcement is going to become a lot more difficult. So that's the bad news. But there is a flip side to this, which is what can we do about it? And the silver lining, if I can call it that, is that this is covered in the withdrawal agreement for run-off cases. That's to say, legal proceedings that are instituted before the end of the transition period and related legal proceedings. And there's been some debate over interpretation of that, but certainly the European Commission notes on this are to the effect that enforcement proceedings would be related proceedings to the main action. So the important thing is to institute the main action before the end of the transition period, which is to say before the stroke of the midnight hour, or should I say 11 p.m. on the 31st of December. So if a claim has been instituted before the end of the transition period, then the jurisdiction provisions of Brussels recast will continue to apply to it. Now, that's jurisdiction. What about recognition and enforceability? And if we can go forward a slide, I am pleased to say that this is also dealt with in the withdrawal agreement in Article 67.2, and that provides very similarly to jurisdiction that the Brussels recast provisions on recognition and enforcement shall apply to the recognition and enforcement of judgments given in legal proceedings instituted before the end of the transition period, and to authentic instruments formally drawn up or registered and court settlements approved or concluded before the end of the transition period. So if you have a child case, which is pre-issue, but where you have an infant settlement approval before the end of the transition period, that's going to be recognised and able to be enforced under Brussels recast after the end of the transition period. So the clue about what we should be doing is in everything I've just said, and if you could put the slides forward one. The key thing is issue proceedings before the end of the transition period to be able to benefit from Brussels recast rules on jurisdiction, recognition and enforcement. Now, there is a further issue on this, which is whether issuing is enough and what to do about service. And obviously, this is something that's quite important because it's all very well issuing proceedings, but if you have to serve them too, that's another matter altogether. And I'm not even going to attempt to read out the name of the regulations which seem to deal with this to an extent. But the important thing is whether the court is seized with the proceedings. And the general rule here, of course, is this is when they are lodged with the court. But unless the claimant has failed to take such subsequent steps as to serve as are necessary. Now, my interpretation of that is you don't have to have served for the court to be seized, but if you then don't serve or don't serve in a way which is permitted, then essentially the fact that the court has seized proceedings will lapse. And if you don't serve, then the court won't be seized with them. But there is a further issue, which is that certainly in some jurisdictions, the date of issue is deemed to be the date of service. And we also have the factor that if you're dealing with a claim against an insurer, you want to serve on the UK handling agents, and it's going to be much easier to do that before the end of the transition period. So this takes us on to the next slide, which is therefore prudent to issue and serve prior to the deadline to avoid any issue being taken with the validity of either issue or service. Now, we had a question about this just before we came on air. I like saying that, which is what happens about serving if you have a case where you've issued before the end of the transition period, so you're in Brussels recast for jurisdiction, but if you haven't managed to serve before the end of the transition period, what happens then? And most importantly, do you need to make an application for service out of the jurisdiction? And this is an issue where some people don't agree, I think it's fair to say. The fact that people don't agree about it, just to my mind, emphasises why by far the most prudent thing to do, if at all possible, is to issue and serve before the end of the transition period, to just avoid any sort of costly argument about it, or even worse, an adverse decision. Because just because something is my interpretation doesn't necessarily mean that a court is going to always do exactly what I ask it to do. But I think that the answer to this is that if you look at the rules about when you need permission to serve out and when you don't need permission to serve out when you are relying on Brussels recast. And it seems to me that if you've issued before the end of the transition period, it is Brussels recast that gives the court jurisdiction. And on that basis, the rules will apply on the basis that you're relying on Brussels recast and therefore you don't need an application. Now, that's my interpretation, but it is not everybody's. And it's better to avoid it not being your case where you're having to have a squabble about it with a defendant saying that the service was invalid because you didn't have permission to serve out. I have to say, I can't imagine the courts are going to want to allow a situation where all of these cases need to be the subject of an application for permission to serve out. We've got an enormous court backlog as it is. We're going to have the courts inundated with avalanche of claims issued before the end of the transition period. And if all of them need to be the subject of an application to serve out, it's just going to add even greater burden to an already very overburdened court service. Now, at this point, I'm going to hand you over to Sarah, but I just want to check to make sure that there's nothing in the chat that we need to deal with. There's an awful lot about torpedoing of torpedoes. I think we've done that to death for the moment, I think. So it doesn't look as if we've got any open Q&As because Sarah's been doing such an efficient job of answering them as I've been speaking. But let me hand over to Sarah then to talk about what happens next.
Yeah, thank you, Andrew. Yeah, we've just had a very smug comment from Chris Deacon saying that it's all academic for him because he's absolutely fine. So we can all stop worrying about Chris Deacon. And, you know, I've been losing sleep over that and now I can stop, which is great. But I mean, I think for anyone who's still got cases, which they are either yet to issue or yet to serve, it's probably a good idea to get on with it because my festive Christmas reindeer tells me there's only 15 days left till Christmas. And after that, you really do not want to be finding yourself in a situation where you're spending the entirety of the week between Christmas and New Year running around attempting to either issue things or serve them. And of course, there is a problem that if you are issuing things online, for example, you need to get the proceedings back before you can serve them. So we are getting sort of towards the end of the time that we can reasonably do this. And we've got this period of grace of a couple of weeks where I think it is most prudent to issue any of these claims with a foreign element. And they're not just foreign claims, some of them are English claims, but they've got foreign defendants. So for example, if you've got a road traffic accident which happens in England, but there is a Romanian defendant, then these are issues which are common to those as well. And of course, the big one is going to be the difficulty of serving after this transition period goes, because we've all been serving on UK handling agents and we're just not going to be able to do that anymore. And the foreign insurers, there's no reason why they should make our lives easier, and they will all have to be served out. And serving out is going to be something of a nightmare come the new year, because the foreign process section is already under enormous stress. And they've had this COVID backlog, and they're now going to get this enormous lump of cases that are coming through just before the end of the year, or just after the end of the year rather, and they're going to have to serve them all. So there is going to be quite a lot of delay, and I know that this is not strictly speaking the topic that we're supposed to be talking about, and again I'm going to get into trouble with Emma, but I just want to sound a word of caution about that, because if you are asking the foreign process section to serve anything, you are going to need to apply for an extension of time within the lifetime of the claim form. And it's surprising how many of these cases, certainly I've seen this year from other Brexit deadlines, where people were trying to serve abroad, not RTA cases, but others, particularly cosmetic surgery cases, and people were trying to serve abroad. The foreign process section wasn't able to serve within the lifetime of the claim form, and people have left it until after the lifetime of the claim form to apply for an extension of time, which is very difficult, or till right at the end of the lifetime of the claim form. And actually, the courts are unsympathetic to that, I find. So they're quite unwilling to extend the lifetime of claim forms on the basis that we have problems with pre-Brexit or COVID issues. And it's been quite a mixed bag of results there. I would have thought the courts would be quite sympathetic to it, but they are not. And this just goes to underline what Andrew's been saying, that just because I think something, clearly I'm right, that doesn't mean that everyone else is going to agree with me though. So it is more prudent, I think, to issue and serve prior to the deadline, if at all possible. And I've been getting quite a few queries from people asking about how one does that if you don't have all the information that you need. So for example, there are some cases where we don't really know how much the claims are worth because they're subject to foreign law. The answer to that is that you just have to take a guesstimate and hope for the best, but make it clear what you're doing. So value the claim insofar as you can, but make it clear to the other side that that's a valuation that is based on a best guess. Alternatively, there are lots of cases where we don't have schedules of loss or we don't have medical reports ready yet. And this is where the difficulty arises with the COVID pandemic, that we haven't been able to get that information or get those medical reports as a result of the pandemic. And so I think you have to plead that and say, well, we're having to issue these claims because of the Brexit deadline, and we're having to issue them without the things that we would want to give you as a result both of the Brexit deadline and of the COVID pandemic. And I think if one is open about that in particulars of claim, it makes it much easier to then say to a judge, well, look, we've done everything that we could do. The converse of that is that if you're a defendant, you need to take a view on whether, when defending these claims, you raise those issues in your defence and say, well, you know, we're taking a point on this. They haven't got a medical report, they haven't got a schedule. And I think that can be quite useful in the sense that you can get yourself a stay by saying, well, look, it's going to be stayed until the claimant produces either the medical reports or the schedule of loss. But I think it's very difficult to get a claim struck out on that basis. So it just depends whether you want to stay or not. But actually, the defendant is entitled to know the nature and the extent of the claim that it is meeting, not as a matter of formality, but because you need to know that before you can deal with something proportionately. If we don't know how high the value of the claim is, we don't know how much money to put into defending it. So that, I think, is the way to handle it if you want to stay and you act for defendants. Now, having said all of that, what are we going to do after the 31st of December? Well, in answer to an earlier question, the UK has applied to join the Lugano Convention. It is supported by the EFTA states. The problem with the Lugano Convention is that the EU doesn't support our accession to it. So the Lugano states are agreeing that the UK should be allowed to join the Lugano Convention, but the EU, which is also a party to the convention, does not agree. What's the effect of that? Well, accession is a four-stage process. We requested accession in April. We need the unanimous approval by the contracting parties. We don't yet have it. If the EU continues to object to us joining Lugano, we can't join Lugano. And that's the bottom line. If the EU does agree that we can join, we then deposit the instrument of accession, and there will then be a 3-month objection period before it enters into force. And a contracting state may object at that point, which will mean that the Lugano Convention does not enter into force between the UK and that state. So we have all been looking at Lugano as if it is the answer to the problem. It's not. One of the reasons it's not is that it's not under any circumstances now going to come into force seamlessly on the 1st of January, because we just do not have time for that. Another reason Lugano is not the answer is that it may be that the EU might approve to our acceding to Lugano and then object, which would then mean that we would only have the Lugano Convention in force in relation to the EFTA countries, but not in relation to the EU. Or alternatively, a state might object. So there are various different permutations on what might happen with Lugano, but what isn't going to happen is that it's not going to come into force on the 1st of January. So there will be, on any view, a 3-month period in which we have, at present, no idea what's going to happen. So that's one of the issues with Lugano. Now, if Lugano does come into force, and I think most people think that that is eventually the route that we're likely to go down at some point, if it does come into force, the provisions of it are not identical to recast Brussels. And actually, this is where being very ancient comes into play, because I can remember what was going on before recast Brussels. And the Lugano Convention is more like the Brussels Convention than the recast Brussels Convention, which means that if we do accede to Lugano, we're then going to be in a position where our jurisdictional rules and our rules on recognition and enforcement of judgments are going to be the old Brussels rules. The issue we have with that is that there is a reason why they recast Brussels. And the reason is that some things under the original Brussels Convention were found not to work terribly well. One of the issues is that the courts of non-EU contracting states are not bound by the CJEU, but take due account of its decisions. And quite what that means is something of mystery. It's probably enough to satisfy Nigel Farage, but it might not be enough to satisfy the pro-EU contingent, because the court can take due account but ignore the decisions of the CJEU. And that's something that we as English common lawyers find it quite difficult to understand as a concept, but that is the concept under Lugano. There's no mechanism to penalise us for failure to comply with the convention within the terms of the Lugano Convention. But most importantly, we're back to torpedoes again, which is why it was very important for me to establish whether or not you can torpedo a torpedo. Darius thinks you can. Exclusive jurisdiction clauses will not carry the same weight in an Italian torpedo context. So under the Lugano Convention, it is possible to torpedo an action by bringing proceedings in some other jurisdiction other than England and Wales, even if there's an exclusive jurisdiction clause which gives jurisdiction to England and Wales. And that means that your potential other party can tie up those proceedings in the courts of a foreign state, and there is nothing you can do about it. So we did have some questions before we started about whether or not choice of law clauses are going to be as strongly enforceable after the 31st of December. The answer to that is that they will not be, partly because even if we do accede to the Lugano Convention, they're not going to operate in the same way as the final answer. So the recast Brussels Convention strengthened exclusive choice of jurisdiction clauses. Under Lugano, they're not as strong, so it's possible to torpedo them. So those are some of the issues that we have with Lugano. If we don't accede to the Lugano Convention, will we revert to the pre-EU position? So these are going to be the rules that are going to be operational after the 31st of December. So between that point and when we accede to Lugano, if we do, or alternatively just going forward forever. Consumers will still be able to sue in respect of consumer contracts. So that is a saving, which does preserve the position for consumers. In relation to others, though, jurisdiction is going to be based on common law rules. And that is something which effectively we've been dealing with when we have rest of the world cases. So this is not unusual, this is not uncharted territory for us, but it is a disadvantage to claimants, and it's also a disadvantage to defendants, because the whole point, as Andrew was saying, about the recast Brussels Convention is that it brings clarity and certainty. Under the common law rules, there is no such clarity or certainty. It just so happens that I did a jurisdictional challenge under the common law rules yesterday, and the judge indicated, I think, that it was pretty finely balanced. We will be seeing quite a lot of those cases now on the common law rules on jurisdiction as to the balancing exercise that the court will have to be performing. And it is never good to have a situation where you have a judge performing a balancing exercise in which you take account of all factors, because it means that you can't predict with certainty what is going to happen. And that's why it's so important that we issue and serve as many of these claims as we possibly can, because everybody needs the clarity and certainty that the recast Brussels Convention brings. So under the common law rules, the claimant has to bring him or herself within one of the tort gateways. And the two most relevant ones for our purposes are that damage has been or will be sustained within the jurisdiction, and we know that that can be indirect damage. So the injury, for example, doesn't have to take place in England and Wales, as long as there is medical treatment, care provided, the effects of the injury are felt within this jurisdiction. So that's going to cover most personal injury cases, apart from the very low value ones, probably. Or you can bring yourself within the jurisdiction if there is an anchor defendant. So if there are proceedings against somebody in respect of which the court will take jurisdiction, and the person you propose to serve is a necessary or proper party to the claim. This again will give rise to arguments about whether or not the mere fact that there is a main claim ongoing in the jurisdiction should then anchor others. And we have seen recently quite a cluster of cases in which anchor defendants have not been enough for the English courts to take jurisdiction. Now, of course, you'll recall that under recast Brussels, if you've got an anchor defendant, you can bring other people in as of right. Under the jurisdiction of the common law, you can't. And the reason for that is that even if you get through the jurisdictional gateways, you've then, in addition, got to satisfy the court that England and Wales is the proper forum in which to bring the claim. So you remember that Andrew was saying that we don't have arguments about forum non-conveniens and forum conveniens under recast Brussels because of the case of Owusu. You do in the common law. So even if you can bring yourself within one of the jurisdictional gateways, that's not the end of the story. It means that the judge then goes on to consider whether or not England and Wales is the most appropriate place within which to hear the claim. And that is something that the claimant has to show. So the claimant's got to prove that the courts of England and Wales are the proper forum, most appropriate forum, by reference to a non-exhaustive list of factors. Things like choice of law clauses are important, but they're not determinative. Things like the language of a contract being English, quite important, not determinative. So there is no determinative factor that you can point to say this is the proper forum or this is not the proper forum. You look at all the factors in the case. Where are the witnesses? Where would the trial most conveniently be held? Where did the accident happen if it's an accident? Where are the parties based? Where are the insurers based? How many claimants? How many defendants? And it is possible to come quite unstuck. So even if there is an exclusive choice of forum agreement, it may not be that the courts of England and Wales will accept jurisdiction, even though the parties themselves contracted that they should at the time of the contract. So in answer to the question that we had prior to the webinar, exclusive choice of jurisdiction clauses are going to be much less important than they were previously, although they are still of relevance and importance. Lastly, in order to take jurisdiction in the rest of the world cases, it must be possible to serve the proposed defendant either outside or within the jurisdiction. Service is going to get much, much harder. Andrew was talking about serving on UK handling agents. That's now not going to be possible under the rules of the common law. So in each and every case, one will need to determine how to serve the foreign defendant. And it's not always straightforward. It's going to have to take place through the foreign process section if you want to be absolutely sure that you're getting it right. And there are some jurisdictions in which rules on service are very peculiar. In some jurisdictions, personal service is the absolute gold standard. In other jurisdictions, personal service doesn't work at all. And I have seen different advice on that. In, I think, Spain, we had one lawyer who said that personal service was the best thing to do. We had another who said that personal service actually didn't work at all. So one's got to trust one's foreign agents in relation to these cases. But you'll see from that conflicting advice that actually the certainty that we had under recast Brussels and the certainty that we had of serving on UK handling agents was a real boon, and that's going to give rise to issues clearly. Might the Hague Choice of Court Convention provide an answer? Rhetorical question, answer is no. The Hague Conventions will be implemented by the Public International Law Implementation of Agreements Bill, which has passed and is awaiting royal assent. This is the one that everyone made a fuss about because it meant that we were breaching international law. They will bring the Hague Conventions into law, but it's not a complete answer. And the reason it's not a complete answer is on the screen in front of you, they don't apply to most of the claims that we deal with. They do provide an answer in purely commercial matters between two businesses, but not in all of these important exceptions. There is a spat between the UK and the EU who disagree about the date of commencement for the conventions, but for our purposes don't propose to go into that because there's no answer to it. And in addition, it seems to me that actually Hague is not the answer here in relation to most of the work that we do. Now, that's jurisdictional canter through, but actually one of the major problems we've got here is also enforcement. I feel a bit doom and gloomy. I feel like I've been nothing but pessimistic so far. I feel sure that we'll end on an upbeat note, however. But actually enforcement is a real problem because we'll have to fall back on international agreements on recognition and enforcement of judgments. And those agreements tend to be, to contain clauses in relation to public policy arguments. So effectively, there are various bilateral agreements between England and the one that I saw most recently, England and the UAE. But within those agreements, they tend to have articles which say that if the enforcement of a UK, for example, judgment is contrary to public policy in that nation, then it doesn't have to be enforced or recognised. Now, that was possible under Recast Brussels as well, but it was very, very unusual for one EU member state to say that it was against public policy for that state to recognise or enforce an English judgment. Is going to be much stronger, that argument, under these bilateral agreements into which we will have to enter if we do not get an answer such as Lugano. So we will have to start taking foreign law advice as to whether or not English judgments are going to be enforceable within foreign jurisdictions. And I'm afraid that we'll have to do that in relation to each and every jurisdiction until we get a clearer picture as regards the bilateral agreements that are in existence. And that is why it is so important to issue and serve prior to the end of the year. And I know that we have laboured this point, but it is by far and away the most prudent course, because not only does it mean that you can issue properly, not only does it mean that you can serve in the UK on handling agents in motor claims, and service is much easier and clearer. Also, it's going to mean that your judgment is recognised and enforceable in the courts of those foreign nations. And for that reason, it's most prudent, I think, as we've said on the slide, if you can't issue before the end of the year, it might be better to give it some months before you issue, because in respect of those claims which are issued in, say, January, before any replacement comes in, the sort of Lugano or any other replacement, is going to be very unclear as regards whether or not those claims are going to be recognised or enforceable. Because at the moment, we don't have those bilateral treaties in place for the recognition and enforcement of our judgments. And there may be some claims that fall through the cracks. So if you issue in January and you get a judgment in June, well, that would be extremely ambitious. But let's say you issue in January, whenever you get your judgment, is it going to be enforceable? Is it going to come within a bilateral agreement? Are the bilateral agreements going to be retrospective? Very probably not, but who can say? So it does mean that anyone issuing anything in January with a foreign element to it is running a risk that when they end up with their judgment, they get a UK judgment against a foreign national that simply cannot be enforced. And that actually is just the worst of all possible worlds, because you've got your judgment, but you can't get your damages. It's a bit like Thomas Cook all over again. So that is a summary of the advice that Andrew and I have to give, which is effectively to try and issue and serve all of these to avoid uncertainty, because what is really, really important is that we don't end up, all of us, in test cases. And there is a particular risk of professional negligence test cases, I'm afraid, in relation to people not issuing and or serving. And it would be possible for an argument to be made that because these issues are being raised now, that one ought to know that it is negligent not to do that. So I think we are likely to see some professional negligence cases arising out of this, and nobody wants to be on the receiving end of one of those. So that's the advice, that the best advice that we have in relation to what to do with your cases with a foreign element at this time. And it's not great news, but I think it's just a question of getting your head around this is something that it's necessary to do. I know that Andrew agrees with me.
I do, yes.
So do we have any questions, Andrew? I know you look as if you've been busy looking things up.
We do have, well, we have a question from before the webinar, which was about data, which isn't really something that was, that's the main sort of subject matter of the webinar today. But I will do my best to answer it. The problem with data is that the European Union is its own, this is where we come on to bubbles, in fact. The European Union is its own data protection bubble or data protection area. And the effect of the UK coming to the end of the transition arrangement is that the UK becomes its own separate data protection bubble. And the EU guards its data protection extremely carefully, and is probably the most data protected area in the world, and is very, very fussy about data coming out of its area. And the easiest way to do transfers from outside the EU data bubble is if there's been a decision on equivalence by the European Commission, basically, which says that the other data protection bubble has an equivalent level of protection to the EU. And as is, the theme of our talk, this is something that is supposed to be happening but hasn't happened yet. And no decisions yet been taken about by the European Commission about whether or not they think that the UK is equivalent. Now, on one level, perhaps you think this shouldn't be a difficult decision because the GDPR is going to continue to apply in the UK after the end of the transition arrangements. We have enacted that as a matter of domestic law, so it's going to be all systems go on that after the 31st of December. So we will be implementing the same rules. The difficulty is, as I understand it, that the European Commission wasn't particularly happy with the way that the UK was dealing with data, even while the UK was a member state and during the transition agreement. And the Court of Justice of the European Union has struck down some previous attempts by the European Commission to make equivalence decisions in respect of the United States. And I imagine there's going to be quite a lot of concern in the European Commission not to make an equivalence decision for the UK, which is liable to be struck down by the court later on. So that's hopefully there will be an equivalence decision by the end of the year, but it's certainly not guaranteed. And the alternative are SCCs, or standard contractual clauses, whereby the entity in the UK enters into an SCC with the EU data controller, basically committing itself to applying very high level of data protection to the data that's being transferred. And I think that's going to be the answer to doing data transfers for the time being. This is quite a complicated and technical area. I'm pleased to say that the Information Commissioner has an extremely helpful section on this, particularly designed for smaller companies, which includes a sort of ready reckoner guide so that you can see what it is you need to do and where the problems might be. And it's very much tailored to a particular case. So I'll be very happy to share the link to that after the webinar. But that would be my advice to anyone who's in this situation, would be to look at the Information Commissioner website, because hopefully that will be able to answer your question in quite a lot of detail, a lot more detail than what we were able to do just on a high level basis in the webinar today.
It's basically the same advice, isn't it? It's all very unclear. Is that the answer?
Well, I think there's a more specific answer, which is an SCC, a standard contractual clause. But hopefully there'll be an equivalence decision before the end of the year, but we don't know whether or not there'll be. So the fallback is the SCC.
Now, we've had another question, Andrew, and this is a situation. I have issued protectively against the defendant driver, Polish national resident here, and the UK insurer. The insurer has nominated solicitors to accept service for the driver. Medical evidence awaited. Would you serve the claim form and apply for an extension for medical report to his claim and schedule pre-31st December? I would serve the claim form with particulars, and I would serve the whole lot if I could. I'd serve as much as I could, is what I would do. I would definitely serve the claim form, and I don't see a reason why you can't serve particulars as well. And I would say in the particulars, we haven't been able to get the medical report yet as a result of COVID and Brexit, and therefore we're not serving those, but we'll serve them as soon as we can. And I would try and get those together as quickly as I could. If I were the defendant in that case, I would then complain and say there's no reason why you can't get a schedule together because you can take instructions from the client. So that's what I would do, I think. Andrew, any thoughts?
I agree with that. And there is a relatively helpful authority about serving proceedings without a medical report called Mark and Universal Coatings and Services Limited. And what I can do, this may or may not work, is I can try and put this in the chat so you've got the citation for that, or even type it as an answer in there. Hang on. And
that's like Nick Lucas has just said exactly the same thing, Andrew.
Oh, okay. So hopefully I've put the citation to that case in there. I mean, really, what that is to do with the need for relief from sanctions application if you've done that. But basically, I also would say that if you do serve with anything incomplete, medical evidence, schedule, etc., the really important thing is to do everything you can to correct this as soon as possible, because what you really don't want is for this to come before a court on someone having made an application and not to have resolved it. And then particularly the schedule, this is something you can take instructions on now. Even if the schedule isn't finalised, identify the heads of loss. Past losses should be capable of being quantified. Really, the more you can do, the absolute better.
Chris is saying, does it matter if UK insurer and Polish defendant driver domiciled in UK is not a recast case? It is if they're a Polish driver, isn't it? Because the tortfeasor isn't the UK insurer, unless I'm missing something.
I was assuming that we were talking about an overseas insurer. Are we talking about a UK insurer?
UK insurer, but the tortfeasor is Polish.
So if we've got a UK insurer as the defendant, then we've got a defendant that's inside the jurisdiction. But all the same, my advice on this is, in these cases, issue and serve, as we keep on saying.
And the other question that we were asked is about SMEs and contracts of employment. And this is to do with, is Brexit going to affect that? I'm not completely sure what the questioner was asking in relation to that, but certainly it's not going to affect, it won't affect anything in relation to employment law as of the 1st of January. Quite a lot of our employment law comes from Europe, but it's not been dismantled, so it's been preserved because it's domestic. So employment lawyers are not having these agonised conversations that we're having because actually they're not affected by Brexit because their law is still going to be the same. If the questioner is asking about movement of people,
that is going to be affected.
That is going to be affected, yeah. But that's not a legal matter. That's more of a practical
immigration.
Yeah, immigration matter. But
there is another reservation for jurisdiction in employment matters, which is part of the amendments to the Civil Jurisdiction and Judgments Act. So akin to the consumer one for jurisdiction in employment matters.
Now, what have we got? Yeah, no, but if you have a UK insurer though, and you've got a vehicle that is, returning to the previous question, and you've got a vehicle that isn't registered here or used here or based here, then you don't have a right of action against the insurer, do you? because we didn't implement the directive properly.
Yeah.
So they're only joined as an interested party because they haven't committed a tort and there's no direct right of action against them. Does that make sense?
I'm afraid I've actually lost the plot slightly on the basic facts of the original question. But
no, you don't have a direct right of action. You see, Jasmine knows. I don't know why you don't know. It's because the UK didn't implement the Six Motor Directive properly. It means that if your car that is involved in your accident is not based in the UK and it's a foreign driver, you don't have a direct right of action against the insurer. Although you do in every other member state of the EU because everybody else implemented it properly. I don't think we did it deliberately, actually. I think we just messed it up. We just didn't implement, which means that you don't have a direct right of action against your UK insurer. You're only bringing them in because of the other defender, because of the tortfeasor. So arguably, you could be subject to an abuse of process argument if you've only brought them into anchor and you don't have a direct right of action against them because there's nothing on which it can bite.
But if the driver is actually domiciled in England, then
no, the driver's domiciled in Poland.
Right.
So you've got a Polish driver who you wouldn't have jurisdiction over, or might.
Right. Sorry, I thought. Yeah. Okay.
And you've got a UK insurer who you would have jurisdiction over because they're domiciled here, but you don't have a right of action against them.
Another point that occurs
we're arguing about this suggests that you need to get it issued and served, I think, is the answer.
Another point that occurs to me is that I can imagine a situation where it's sort of borderline whether or not someone really is domiciled here. So if you have somebody who's just here temporarily and they want to make life difficult for the claimant, then, you can imagine a set of facts where you could be having a squabble about whether the driver, if the driver is the defendant, is actually domiciled in the UK or not.
Yeah, in fact, we've got the Polish driver is based in the UK, so we're fine. It's just it doesn't have a foreign element in that case. I've actually got a jurisdictional challenge coming up where the defendant says, who is an EU defendant, says that my claimant wasn't domiciled in the UK at the time of issue, which means that there is no jurisdiction. So we can see that there are going to be arguments of that nature and just more and more of these. And I was saying to Andrew this morning, actually, that I can foresee lots of problems with this, but the worrying problems are the ones that I can't foresee.
Yes, it's really the unknown unknowns.
Yeah.
And, which is inevitable when you have any change on this sort of scale, I think, because one of the things that I think I said at the beginning is a big advantage of Brussels recast is we're all very used to it. And so are the courts. And a lot of the questions that arise in that have already been answered because there's legal authorities on it. If we join Lugano, then we will have the benefit of an acquis, if I can call it that, of previous decisions when points have arisen on it. We won't be inventing the wheel from the beginning, which will mean a lot more certainty and a lot less litigation. So it's probably a bit of a moot point whether that's good or bad news for lawyers, actually, but because more disputes tend to be good news for lawyers, but obviously it's not good news for clients if we can't advise people properly about what the answer is.
Yeah, well, it's only good news for lawyers as long as we're not getting sued, isn't it?
That's true.
But actually, any change of any kind always gives rise to litigation.
Yeah.
In my experience, even if it's just a minor change, and this is a huge change. So I think the answer is to be as prudent as you can possibly be along the lines that we've given.
One thing that came out in a question earlier that was a written question was about the impact of whether Ursula and Boris's turbocharged dinner last night actually means we have a deal. Is that going to give us some sort of get out of jail free card from all of these problems? And the answer to that is no, because a deal is not going to cover these areas. So what we've been talking about will apply whether or not there's a free trade agreement between Britain and the EU. The only thing that may make a difference to it is a bit indirect because it will affect the mood music. And I think in terms of us joining Lugano, the EU seems to be waiting to see what the future arrangements are going to be like before it takes a decision about whether it is happy for the UK to join Lugano or not.
Yeah, I mean, it may be a problem that just goes away, but as I say, it can't go away overnight because we don't have time.
And we're going to have a situation, it seems, where we have basically three regimes in parallel, potentially, because we have the runoff cases being governed by the old rules. Then we have, hopefully, cases several months in the future that are going to be governed by Lugano. And then the in-between cases, which are going to be the sort of common law plus situation that Sarah's been talking about. And probably the worst situation to fall in will be the in-between one. But then it's hard for us to say in a way, because we don't yet know whether we are actually going to join Lugano or not. That is a known unknown, unfortunately.
That's true. We've had a suggestion that we should do this all over again in a few months' time, Andrew. And it may be a good idea for us to reschedule something when we have a little bit more clarity. But
would it be a webinar recast?
Yes. For the moment, I think I never thought I'd be saying this on the 10th of December, but for the moment, it still looks unclear what we're going to have on the 1st of January. But it looks very much as if it's going to be a period of common law rules that goes on for some months. If not,
it's back to 1972, plus the few additional changes that we were talking about.
Yeah. Any more questions? No, super. Okay, well, in that case, it only remains for me to give a final plug to the Festive Case Law Roundup, which Emma reminds me is going to be given by Lisa, me, Connor, and Richard Collier. Next Tuesday at 11 a.m. As I say, it's going to be a romp through the cases of the last year, involving festive ponchos, festive hats, festive jumpers, and me in an elf hat, which I just find irresistible. I can't imagine anyone not tuning in for that. But it'll be 10 minutes per practice group. So 10 minutes of travel, 10 minutes of personal injury, 10 minutes of clinical negligence, and 10 minutes of property and professional negligence. So would love to see you on Tuesday as well. And a hearty hello to all. But I think that wraps it up, Andrew.
Yes, I think so. Well, thank you very much to everyone for joining us today. And thanks very much to people who've contributed to the chat and with questions and things. We hope we've dealt with them. There's one question we didn't answer, Sarah, which was about bananas, I think.
Yes, indeed. The most
that question first. I don't know what we were thinking, leaving that till the end. And now, half of the participants have left and won't find out the answer to the question.
They'll never know whether or not they can eat curved bananas again. Very sad.
And, do we even know, Sarah?
I think the answer is you can eat whatever you want from the 1st of January, which, of course, previously had not been possible underneath the European jackboot.
And most bananas do not come from the European Union, although I think I remember from EU law lectures that I think there's one banana farm in Sicily, but on the whole, they're actually outside the EU. So,
is Madeira in the EU? Because I can tell you they have special bananas there, which taste of pineapple or something else. Madeira is a very odd location. They have this...
What, are they bendy or are they straight there, these Madeiran bananas?
A bit curvy. I think too curvy.
Madeira is part of Portugal, I think, so it is in the EU. So perhaps there's a problem with these bananas. I'm not sure many of them make their way to my local Lidl. Perhaps Whole Foods in Teddington's got a slightly better range of banana options.
Oh, I was eating them on Madeira, Andrew.
Oh, okay.
I go to the location in place of relevance to eat these things. No, the answer is you can eat curved bananas as much as you want from the 1st of January. Thank you for that question. One of the most testing of our legal questions, I think, this year.
Definitely. Want to include in the festive case roundup, I think.
Absolutely right.
Have a recap of some of the best questions from the webinar series. Absolutely.
They'll all have come from Darius.
Well, once again, thanks very much to everyone for joining and participating in, and helping us make this such a hopefully stimulating webinar. And yes, have a good rest of the day.